Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, as you know that we are carrying a series on general course on intellectual property rights, and so far we have conducted numerous sessions, numerous lectures under this very series. Dear friends, in our previous session, that is yesterday, we talked about patent infringement, remedies and relief. We talked on various aspects of the patent infringement and we tried to grab maximum knowledge. Dear friends, today also we would be carrying our lecture forward on this particular topic, that is patent infringement, remedies and relief. And for this we have again with us in our studios Mr. Ashwini Sewal. Mr. Ashwini Sewal is Assistant Professor in IP Laws in Faculty of Law, University of Delhi. Through these erudite lecture, he frequently exchanges information, he shares knowledge so that it becomes easier for you to get in-depth knowledge on intellectual property rights. So, without wasting any time, I would like to welcome our guest, Mr. Ashwini Sewal, and let's have a very deep insight into this topic once again through him. Hello, sir. Welcome to the erudite lecture.
Good morning, Gitika. Thank you very much. Welcome viewers, and I wish you good morning today. Well friends, as Gitika has just elaborated that we are running an intellectual property law series, and in our yesterday's discourse I started talking about the patent infringements and the remedies and relief in case of the patent infringement. Well friends, if you remember yesterday's discourse, I talked about 3 deliverables which to my understanding are very important for a person to discern as to what constitutes the patent infringement and what are the subsequent remedies and reliefs available in case of the patent infringement. Friends, I would like to recapitulate certain important points which I discussed with you yesterday. The very important part and the provision that I discussed yesterday was section 48, which encompasses the rights of the patentee. Section 48 covers lot many rights of the patentee. I mean in the case of the product patent and in the case of the process patent, both the rights are given, or for both kinds of patent rights are provided under the 48. If I take a 1 minute time to just recall 2 important points about section 48. Well friends, 48A talks about the right of the product patent holder, and 48(2) talks about the rights of the process patent holder, and we understood the distinction between the rights of the process patent holder and the product patent holder on the other side. The important point is about the distinction between the product patent holder's right and the process patent holder's right. So, you need to remember that particular right and take care of that right, because only then you will be able to enforce that right. If you will not be knowing and will not be aware about the right provided under the Patents Act 1970 to the holder of the patent or to the owner of the patent, it will be really difficult for you to enforce that right or get it enforced in the court of law. Another thing that I discussed with you yesterday, that there are several kinds of relief available and remedies available in the case of the infringement. One important relief, or you can call it synonymously remedy, that I discussed with you yesterday, it's about opposing the patent in the case of impugned patent protection to be obtained by the person, or in case when the person is seeking to obtain a patent protection which is not rightly obtained by him, or which is not kind of a patentable subject matter or wrongfully obtained patent in that case. Well friends, if I would like to recapitulate one more important point, see section 25, if you rightly remember, talks in 25(1) about the pre-grant opposition, and under 25(2) it talks about the post-grant opposition. These 2 separate clauses are kind of different clauses altogether, or 2 different subsections are there covering 2 different issues. One covers the pre-grant opposition, another covers the post-grant opposition. Well see friends, 25(1) as discussed and threadbarely analyzed by me yesterday talks simply about what pre-grant opposition proceedings, wherein we have understood that any person can file the pre-grant opposition and can go to the patent controller in writing, filing his patent opposition in writing, and the time frame when he can file, I mean when he becomes eligible to file the patent opposition under section 25(1) has been specifically provided under 25(1), and 25(1) in its very first sentence says that after the publication of the patent application and before the grant of the patent, I mean, it is quite easy to understand to all my viewers that at the stage when the application is in process, I mean the patent has not been granted yet, and the publication of the patent application has been done. So friends, if you remember that publication for the same is done by the patent office, and usually the patent office takes 48 months of time to publish the patent application of the person, and within that application request for the publication entertained by the patent office, within 1 month's time the patent office publishes the patent application. So whenever the patent application gets published, it's not whenever the patent application gets granted, it's about publication of the patent. Whenever the patent application is published and before the expiry of the patent, the patent controller receives the oppositions, and 25(1) provides enumerates a long list of grounds available to a person in the case of opposing the patent filed by somebody. That is the stage where the patent has not been granted yet, still the person has been made eligible by the statute, by section 25(1) or by its purview, that he can go for the filing of the patent oppositions he can file against the patent application of the applicant. Well, another thing that we discussed yesterday, friends, if you remember rightly, I talked about 25(2) little bit, where I have not discussed yet the grounds enumerated under 25(2), but 25(2) is a provision, is a clause, is a subsection of section 25, which encompasses several grounds, for post grant opposition. Well, whenever it comes to remedies for the infringement, whenever it comes to relief in case of the infringement, 25(1) and 25(2) they can be availed, especially in the case of 25(2), or especially section 25(2) is of much use, because 25(2) is the provision which furnishes the grounds to the third person or to the interested person to file the post grant opposition. I mean, the grant has been already conferred by the patent office to the applicant for his invention or for his claim. Now the third person, I mean any person interested in that particular situation, here there is a little difference vis-a-vis to 25(1), because under 25(1), friends, it was any person who can file the patent opposition, pre-grant opposition, but under 25(2), during the post grant oppositions, only the interested person, only the person who is interested or who can be called an interested person is eligible to file the patent opposition. Well, friends, I would like to distinguish between these two, 25(1) and 25(2) in today's discourse, as well as I would take you to another important kind of a remedy available, that is called revocation under section 64, which we will discuss exhaustively in a very meticulous fashion. And one more thing, I mean, any time a aggrieved person or any person or interested person can go to the court for the invalidation of the patent if its validity gets challenged and validity does not get proved. Well, friends, I would like to take you to our important agenda for today, which if you remember properly and correctly, I have discussed to an extent yesterday that what are the rights of the patentee. I have covered this part yesterday, so I will not be focusing on this part today. Another important thing, what constitutes infringement. So see, if you remember section 48 and its language, it becomes aptly clear as to what constitutes infringement, because under section 48 in its main language, it has been provided that whosoever sells, offers for selling it, and imports any product into India which is a patented product, obviously, of course, then in that case that amounts to, or that tantamounts to infringement done by that person. So there are several acts which are covered under 48A which are amounting to infringement, and 48 provides the rights to the holder of the patent, be it a product patent holder or a process patent holder for that matter. Well, the third thing that we are focusing in our today's deliverable, that is what are the remedies and relief for patent infringement. As told by me just now, that there are three major remedies available to the person in the case of patent infringement, and those remedies I will be covering one by one. Well, see, these are the multiple remedies for patent infringement as highlighted on your screen. These are the multiple remedies for patent infringement. Friends, opposition can be filed under section 25, especially 25(2). Opposition proceedings of 25(2) can be made a right recourse to approach the patent controller in the case of any kind of a ground mentioned under 25 and especially 25(2), I mean, and any person who is interested in filing or filing such kind of a post grant opposition can approach the controller and get it filed to him. He will take certain time to decide. Of course, he will provide an opportunity to the applicant for listening him. I mean, he will be given a full opportunity to be heard at that point of time. The another remedy in case of patent infringement is the invalidation. I mean, if somebody is going to institute a suit for the patent infringement, he can get the patent of the impugned person invalidated, or he can get the impugned patent invalidated on several grounds available under the Patents Act 1970. Or if any interested person thinks so that the patent has been erroneously granted to some person, so in that case that person can also always go for the invalidation of the patent, and invalidation proceedings will start at the High Court level, where they will be listening about the validity and the genuinity or the veracity of the patent protection granted by the patent controller in that case. The third thing that I would like to tell you about remedies in the case of the patent infringement, that is a revocation under section 64, which I am going to discuss in a very detailed fashion and detailed manner today. This revocation provides several grounds of section 64. You can say, speaking through section 64, there are several grounds provided under this section which furnishes a locus for a person to go for the revocation proceedings to be filed either to the IPAB. I mean, revocation proceedings will always be filed to the IPAB, and if somebody has instituted an infringement action against you, then in that case you can file the revocation in a counter claim in that particular infringement suit. That has also been provided. That kind of a remedy or a mechanism is also given under section 64. I will specifically emphasize on this point when I will show you the language of section 64. Well friends, as far as opposition proceedings are concerned, the very first remedy in the case of the patent infringement, that is opposition under section 25, which I have discussed with you in yesterday's discourse. Especially 25(1) I have covered and completed yesterday. I will be jumping to 25(2) today. I would like to tell all of my viewers that 25(2) has got similar grounds available for going for the post grant opposition. The way they are given under 25(1), similar grounds are given, or verbatim grounds are given under 25(2). The only distinction between 25(1) and 25(2) is that under 25(1) any person can go to the patent of controller for pre-grant opposition proceedings, but in the case of 25(2), viewers, only the interested person, or you can call person interested, can go to the controller's office for post grant opposition. Rest of the people are not allowed. I mean, only interested person, that has to be proved. I will show you certain case law which makes it very clear as to who will be called the interested person in this context, because as such the definition provided of the person interested under the Patents Act 1970 is not exhaustive. That definition does not give a clear or you can say impeccable idea about as to who will constitute or who will be called the person interested. We have some judicial dicta available and judicial pronouncements available speaking or throwing a light on the point of person interested and its interpretation and its construction here. Well friends, let me take you to 25(2), which I discussed with you yesterday. I will take you to 25(2) through the Bar Act, and I would like to highlight one important method of reading of the law. Well friends, whenever you read and whenever you try to read the patent law, you need to see the Bar Act, because without the Bar Act you cannot understand as to what is the composition of the section and as to what all is covered under the section. Well friends, if you have a look at the present slide, I mean the present text available on the screen, that from here the section 25 starts and its marginal note reads opposition to the patent. Under 25(1) pre-grant opposition proceedings are given, and under 25(2) post-grant oppositions are given. What I want to highlight as I have discussed it in my earlier discourse, I mean yesterday, what I wanted to highlight now by putting this particular text on this slide is the very first point, that what is the time frame or during what time period one can go for the pre-grant opposition. That is quite explicitly written under the very first clause. It reads that where an application for a patent has been published, as I mentioned, where an application for the patent has been published but a patent has not been granted, and any person, if you have look at this particular point, that any person, it is not an interested person, it says any person can file the pre-grant opposition. It does not restrict the list or category of the persons to what, to the person interested, rather it says any person may in writing represent by way of opposition to the controller against the grant of the patent of that particular patent application. Well friends, the two things which are noticeable here under 25(1), one is that the time period where one can file or during which time period one can file for the patent application, patent pre-grant opposition, and another thing, who can file it, as written clearly that any person may in writing go to the controller against the patent on the various grounds. The grounds I have discussed yesterday with all of you. I will jump to 25(2) friends, which is quite different from the language of 25(1). If you read under 25(2), which encompasses post grant opposition proceedings, it reads at any time after the grant of the patent but before the expiry of the period of 1 year from the date of publication of grant of a patent. It reads friends at any time after the grant of the patent but before the expiry of a period of 1 year. So it becomes quite clear and simple for all of you to understand that after the grant of the patent one can go for the post grant oppositions, as simply getting clear by the language of 25(2), that at any time after the grant of the patent but before the expiry of the period of 1 year from the date of the publication of the grant of the patent. Well friends, whenever person gets the patent protection on his or her claim, he or she is conferred with the patent, and his or her patent protection is generally publicized, is always publicized, that this and that person has been conferred with a patent on this and that claim. So see, that publication takes place. So before the 1 year, I mean during the period of the publication you can always file, but after the period of 1 year of the publication, before the publication you are always eligible to file, but after the period of the publication of the grant of the patent, it is not the publication of the patent application, it is the publication of the grant of the patent, that the patent has been finally granted and conferred to the person, and now the person has obtained it. It is a matter of notification or say publication of the patent in the journal that comes usually. Well friends, when the patent grant gets published, and any person who thinks that there are, only an interested person who thinks that there are certain grounds on which he can move to the controller or go to the controller for opposing the patent application, patent grant to the person, then in that case 25(2) can be invoked, and the various grounds provided under 25(2) can be invoked, and that person can approach the controller. Written application can be filed to the controller, wherein he will be making or trying to invoke one of the grounds or provided under 25(2). There are several grounds provided under 25(2), which I told are quite similar with the 25(1) grounds, similar in the sense same grounds are getting repeated here under 25(2). I would like to recall certain grounds. First of all, we have a ground in the form of wrongful obtainment of the patent. If somebody wrongfully obtains the invention and tries to obtain a wrongful patent by filing the patent application, then it becomes a ground for opposing that person in at both the stages, under 25(1) at a pre-grant stage or under 25(2) at a post-grant stage. Another ground for approaching the patent controller under both the stages or at both the stages of the 25(1) and 25(2) is the stage where the ground which I call a ground in the form of not having the novelty or lacking the novelty in the claim. If your claim does not have the novelty, in that case also the person can approach the controller and oppose at both the grounds, at both the stages, under 25(1) as well under 25(2). Another ground, if somebody's work is already fallen into the public domain, has become a subject matter of public domain, is not is not a novel thing. Another ground is which I have discussed with you yesterday. It's about lack of inventive step or obviousness, non-obviousness. I mean, if your work is obvious, then in that case you cannot get the patent protection, and any person may file the opposition proceedings for your wrongful work applied by you, which lacks the inventive step in it, Another ground which we can furnish about non-fulfillment of the requirements of section 8 of the Patents Act 1970, which is usually in the cases of the foreign applications. Well friends, if you remember section 8 of the Patents Act 1970, which talks about the foreign applications, if you do not disclose the requisites required to be disclosed by you under section 8, then in that case it becomes, or it furnishes a good ground for pre-grant opposition as well as for the post-grant opposition done by you. Well, I would not cover all the grounds as I have discussed all the grounds yesterday. I would emphasize specifically on point number 2, or you can call 25(2), its beginning sentence, which says that one can file the post-grant opposition after the grant of the patent, but before the expiry of the 1 year from the date of the publication. So, before the expiry of the 1 year, it means what? It is suggestive of the fact that once the patent grant gets published, only within 1 year of time period one can go to the patent controller for filing the post grant opposition on several grounds provided therein. There are several grounds which I will not be covering, as I told that I have covered them, and they are almost similar grounds provided here under section 25(2) as given under 25(1). So, I will jump to another important aspect of our today's discussion. Well friends, another important aspect of our today's discussion is seeing the another kind of a remedy or the relief available, and that is called revocation. Well, I would like to tell something about the revocation. Well friends, section 64 provides a kind of a relief or a remedy in the cases of the patent infringement, and through or by invoking this particular ground, or by invoking this particular remedy of section 64, one can get the patent cancelled or revoked even if the patent has been granted. Obviously, it is a stage where the patent has already been granted. In that case, you can file for the revocation, and grounds for the revocation are also, some of the grounds for the revocation or under the revocation under section 64 I mean, are similar to the grounds provided under 25(1) and 25(2), but there are few new grounds available also under section 64. This I would like to discuss with you, but before starting the discussion on 64, I feel like discussing first of all some of the important points that I missed about section 25 friends. If you remember that I told you that under 25(2), only an interested person can file the patent opposition or can go for the post grant opposition. If you look at section 25 and its composition, especially 25(2), it says and it reads, interested person as per 25(2) can file the post grant opposition. Who becomes the interested person? That is a question of importance, and that is a question to be comprehended and discerned by all of us. Who becomes the person interested in post grant opposition? Well, as per the definition provided under section 2, the person interested for 25(2) and for 64, it is defined under 2(1)(t) friends. Have a look at the screen, that 2(1)(2), which is the definitional clause of the Patents Act 1970 has been provided. It reads that a person interested includes a person engaged in or in promoting research in the same field as that to which the invention relates. Kindly read it carefully friends. It says that the person interested includes a person engaged in or in promoting research in the same field as that to which the invention relates. Well, this definition provided under definitional clause of the Patent Act 1970, 2(1)(t) I mean, does not give us a clear idea about the meaning of the person interested, or does not make us clear as to who will be called or deemed as the person interested, because it is quite ambiguous definition. It includes a person and it is a wide definition. I mean, there is no clarity, there is no precision in this definition. We need to see as to who will constitute the person interested, and for that we need a precise definition. But this definition, as I said, that is a exhaustive one, is a wide one, covering so many people, or providing a scope to cover so many people under its ambit, because it reads person interested includes a person engaged in or in promoting research in the same field. So, there can be several persons engaged in or promoting research in the same field. So, they all cannot become undoubtedly person interested for the purposes of post grant opposition filing under section 25(2). So, we need to streamline as to who will be called or deemed actually the person interested for the purposes of post grant opposition. So, for that I have brought a case law which will, I believe, throw a proper light on this point, or on the definition of the word interested person as per the judicial pronouncements. Under this particular case law in Globe Industries Corporation's patent case 1977, friends, it was clearly held by that court that where the statute uses the words any person interested, where the statute uses the word any person interested, the interest has to be genuine. Well, friends, I would request all of you to kindly carefully look at this ratio provided for the definition of the word person interested. This ratio reads, where the statute uses the words any person interested, the interest has to be genuine. If somebody has not got any genuine interest, he will never be deemed to be a person interested for the purpose of filing of post grant opposition under section 25(2) or under section 64. He can never file it. Another thing that has been provided by this court pronouncement, which reads that person interested would be whom? The person who has got the genuine interest, and the possibility of prejudice has to be genuine. Well, it says that whosoever thinks of filing the post grant opposition, he needs to show that there is a possibility of prejudice to his or her work. I mean, one who is the opposition, who is coming to the opposition, who is an opposer, one who is an opposer, if he proves that there would occur some prejudice to his work, or to what we call it prejudice to his claim or his invention which he has already created or he is already using, in that case he becomes a person interested. And in addition, the court further moves saying that in addition the court must be satisfied that the opposition or the application for revocation, as the case may be, is not frivolous, should not be vexatious or blackmailing operation. Well, friends, as becoming clear from the pronouncement highlighted on the screen by me, that person interested should not be the person interested provided under 2(1)(t), because that person interested, or the definition for the person interested under 2(1)(t) is not clear. It is ambiguous, it is wide, it is broad definition which may possibly cover many people, and many people may take wrong advantage of that particular language. So, that is why the court has come up heavily and said that the person interested should be whom? Only the person who has a genuine interest, only the person who proves that because of the patent granted to the applicant or patent conferred on the applicant, there is occurring a serious prejudice to his invention or his work. And another important thing that has been highlighted by this definition, that says that the court has to be very cautious, that the opposition filed by the applicant or revocation application filed by the applicant, as the case may be, should not be frivolous, should not be vexatious, or should not be a blackmailing operation. If it is just a blackmailing operation, then in that case it is really difficult for the court to entertain it, or for the controller to entertain it, because controller will gonna turn it down, will not listen to the opposition. So, those who are thinking of filing some oppositions, they must be little cautious in first of all satisfying themselves whether they falls under the definition of the word person interested, and those who have already been summoned by the controller or by the court on the opposition filed by somebody, they also need to see whether the opposition filed by the person is a genuine opposition is a opposition filed on the truth, or it is just a frivolous or a vexatious or a blackmailing operation initiated by somebody for taking some sort of a advantage by that person. Well friends, if we see it in the Indian context, we have one important case law of year 1983 of the Delhi High Court, where the Delhi High Court has categorically stated who will be called as the person interested for the purposes of the Indian Patents Act 1970. Let us have a look at this case law friends. It is Ajay Industrial Corporation versus Shiro Kanao of Ibaraki City. It is a 1983 Delhi High Court case. Well, here the person interested has been defined by the court, where the court has clearly stated that this expression is of a broad amplitude and wider than the expression person aggrieved used in the Trade and Merchandise Marks Act 1958 and the Copyright Act of 1957. Well friends, court here has categorically stated that the person interested defined under the definitional clause of Patents Act 1970 is of wide amplitude, is of broad amplitude, and it is wider than the expressions provided under Copyright Act 1957 or the corresponding expression provided under Trade and Merchandise Marks Act 1958, where the person aggrieved has been defined. So this person interested is wider, or its interpretation in amplitude is wider vis-a-vis to the person aggrieved defined under the Copyright Act and the corresponding expression used in the Trademark and Merchandise Act 1958. Well, this Delhi High Court in this Ajay Industrial Corporation case has come up with the tests to determine who will be called, or as to how to determine the person interested, for allowing the person interested for filing the post grant opposition under 25(2) and for allowing the person interested for the revocation proceedings of provided under section 64. So the test is quite simple, as written on the slide on your screen in this case law, which reads that the person interested within the meaning of section 64 must be a person who has direct, present and tangible commercial interest. Well friends, kindly read it very carefully. This is the test to be applied by the Controller's Office, by the High Court in case the High Court confronts any question about the veracity of the person interested, about the authenticity of the person interested. It reads that the person interested within the meaning of section 64 must be a person who has direct, present and tangible commercial interest or public interest which is injured or affected by the continuance of the patent on the register, by the continuance of the patent on the register. Well, what does it say? It says if the patent continues as a registered patent in the patent register, and if it disturbs the fabric, I mean if it disturbs somebody's interest, if it disturbs somebody's commercial interest, if it disturbs somebody's genuine interest, or if it disturbs the public interest being a registered patent in the patent register, then in that case it has to be struck down either by invoking the grounds provided under section 64 or through the procedure provided under 25(2) for the post grant opposition. So what is the keystone, or what is the fundamental rule for gauging who will be termed, or for gauging as to who will be called the person interested, is provided under this test in the Indian context by this case law of Delhi High Court, which clearly says that if being on the register of the patent or being in the continuance as a patent on that claim, if it causes some prejudice to the commercial interest of somebody, or if it causes a prejudice, or if it jeopardizes the public interest involved, then in that case that person whose private interest has been infringed or impinged becomes a person interested for the purposes of this particular act, and for the purposes of section 64 and for the purposes of section 25(2), and he can file the post grant opposition invoking any of the grounds mentioned under 25(2), he can file invoking any of the grounds provided under section 64 for revocation. Well friends, I will move ahead with another important thing which to my understanding is very important for all of you to understand. Well, as I have told you in the beginning that there are 3 remedies or reliefs available under Patents Act 1970 in the case of the patent infringement. One is the opposition proceedings to be filed under 25, especially 25(2) as discussed by me just now, and another is invalidation proceedings, which goes to the High Court challenging the validity of the patent. The third is what is the revocation, and revocation is the most important remedy to my understanding, most important relief available to the person seeking to restore his right, or to the person seeking to get the wrong patent turned down by the patent applicant from the register, or striked out by the patent controller from the register of the patent. That is revocation, and revocation has been provided under section 64. Well friends, I would like to narrate two important points about section 64. Section 64 postulates two kinds of remedies embedded in it. It is one section, but it postulates two options to a person for this thing, for going for the revocation, or for filing the revocation in the case of the patent infringement. One is revocation petition before the before the IPAB, Intellectual Property Appellate Board. That is revocation petition. One files the revocation petition invoking the grounds mentioned under section 64. So one postulate or one kind of a remedy or a relief for the patent infringement is the revocation petition filed to the Intellectual Property Appellate Board. Another is filing a counter claim in a patent infringement suit. Well, I would exemplify it to make you understand as to how one files the counter claim in the infringement suit and invokes the ground mentioned under section 64 of the Patents Act 1970. Friends, one important point that I would like to tell you, a revocation petition, if you see on the screen on the slide, a revocation petition before the IPAB or a counter claim in infringement suit before the High Court are not conjunctive, and a choice needs to be made between the two by the person availing these remedies. Well friends, this is very important and a crucial thing to be noticed by you. Why, I will tell you. See, as I told you that there are two postulates or two kinds of remedies available under section 64, or two methods are available under section 64 for filing the revocation. One is revocation petition to the Intellectual Property Appellate Board, another is counter claim in an infringement suit before a High Court. But what this last part of this slide says, it says that the revocation petition before the Intellectual Property Board or a counter claim in an infringement suit before the High Court are not conjunctive, and a choice needs to be made. They are not conjunctive remedies. I mean, one cannot avail both the remedies simultaneously, or one cannot avail both the remedies. If one wants to go for revocation petition to the IPAB, or feels like going for filing the counter claim in the case of infringement suit, he has to make his choice. I mean, he has to choose one option, either of the one. Either he goes with revocation of the patent application or revocation of the patent granted to the Intellectual Property Appellate Board, or he decides to choose another option available to him, that is the option of filing the counter claim in an infringement suit in the High Court. Either has to be chosen. I will tell you, this is a very important case law which I will be going to discuss with all of you, and a recent case law decided by the Supreme Court in the year 2014, filed in the year 2013. This case law has streamlined the procedure for the patent filing, or streamlined the patent proceeding procedure, especially the procedure of the multiple oppositions or revocations, especially the procedure which curbs the multiple proceedings and multiple revocation proceedings. Well friends, I would like to take you to that case law, but before that I will jump to the language of section 64 to make you understand as to what all are the grounds of section 64 to be invoked by the interested person as decided or discussed by me just now. I mean, the interested person whose definition we have just discussed and understood, that person has got the rights or grounds under section 64 to go for the revocation of the patent application. Let us have a look at section 64, friends. This section 64 is quite a lengthy section and provides so many things. If you look at your screens, this revocation of patent says subject to the provisions contained in this act. Well, the very important point in the very beginning, subject to the provisions contained in this act. What does it mean? It means that this section and its purport goes subservient to the provisions of this act. I mean, other provisions of this act will surpass their operation and applicability in comparison with section 64, because it is subservient to other provisions of this act. Then it moves, it says a patent whether granted before or after the commencement of this act may be revoked on a petition of any person interested. It reads that the patent may be revoked on a petition of any person interested or of the central government by the appellate board or on a counterclaim. Well, this has to be noticed by all the viewers that it here provides two kinds of methods for filing the revocation. One is revocation to be filed or revocation petition to be filed to the intellectual property appellate board. It reads that patent whether granted before or after the commencement of this act may be revoked on a petition of any person interested. It specifically says any person interested or of the central government. I mean, the central government can also file the revocation application and can also proceed with the revocation proceedings to the appellate board or on a counterclaim in a suit. I mean, who all are eligible or who all are becoming eligible to file the revocation proceedings as per section 64, the person interested, as we have understood the definition of person interested, and the what we call it, central government may by application move to the appellate board or file the counterclaim in a suit for infringement of the patent by the High Court on any of the following grounds. So, there are two people or two categories of persons becoming eligible for going for the revocation. One is the person interested, another is central government. And the next thing that we need to understand from this highlighted portion of section 64, it says that the revocation petition can be filed to the appellate board, that means to the intellectual property appellate board, or a revocation application can be moved in a counterclaim in a suit for infringement of the patent by the High Court on any of the following grounds. So, what does it mean, friends? I would like to exemplify it by giving you a real time example. Suppose one entity A holds a patent on something. Just suppose that one entity A holds a patent on something, and they have got the patent protection as they are holding or possessing the patent on it. They are exploiting their patent and the patent's potential. What happens or what transpires? Somebody files revocation petition against them. This is the one scenario. Somebody here means what? That the patent has been obtained by entity A, and somebody here means any person interested can file the patent revocation to the intellectual property appellate board. Another scenario, or you can say another entity or another category of persons who can file, the central government can also go to the intellectual property appellate board against the patent held by entity A. One situation. Another situation, or you can say one more postulate of section 64, where the entity A files an infringement action against somebody, say against Mr. B. Entity A possesses a patent. Now they are instituting an infringement action against entity B. When they institute an action against entity B, or when they institute an infringement action against entity B, this entity B has got a right as per section 64 to file the revocation in a counter claim in that infringement suit. Who has initiated the infringement suit? Entity A, who is possessing the patent. But somebody else against whom the patent infringement proceedings has been started, they can always file a counter claim against entity A in the same suit, which is an infringement suit in this context. So, an infringement suit has been filed by A, but entity B in this case is filing a counterclaim, and counterclaim as decided by the courts in many decisions in catenary of cases is equivalent to what? Counterclaim is equivalent to plaint. It is equivalent to plaint, as if they are bringing a plaint against the original initiator of the patent infringement proceedings. Well, that is how revocation can be filed on the several grounds mentioned under section 64. If you have a look at the grounds mentioned under section 64, we have lot many grounds provided under section 64. But as I told that there are many similar grounds which we discussed under 25(1) and 25(2). So, I will not be repeating all the points. Still, I would like to take you to the language of section 64, especially 64(1)(a), which reads that the invention so far as claimed in any claim of the complete specification was claimed earlier on a priority date. What does it mean? That the claimed invention, or say the person who is claiming the patent protection on his or her work, has not filed earlier than that somebody else. I mean, somebody else has filed it earlier, one thing, where his claim will not be called first in time. It will never be called first in time because somebody else has filed it on an earlier occasion. Another thing, that the patent was granted on the application of a person not entitled. I mean, his subject matter is doubtful, is skeptical. He has not filed a patent on something which is eligible to be granted a patent protection, or on something which may fetch the patent protection. He is filing a patent application on something which will never be able to get the patent protection. Subject matter is missing. Another ground where somebody does what? That the patent was wrongfully obtained by him. He is not the true and first inventor, still he tries to get the patent on something which he has wrongfully obtained, falsely obtained from some source, or stolen from some place. Another thing, does not define the complete specification clearly, that the subject of any claim of the complete specification is not an invention within the meaning of this act, that the invention so far as claimed in any of the claim is not new. Again the same point which I have discussed with you, it has fallen into the public domain, has anticipated earlier, not sufficiently and clearly and fairly describing the invention and the method of the working of the invention, not fulfilling or conforming with the requirements under section 8, that the patent was obtained on a false suggestion or representation. So, there are so many things which one can see or find as the ground for going into the revocation. But what is the most important part of the revocation proceeding? That he has to be an interested person first of all. An interested person's definition we have understood from two case laws, and the definition of the interested person will remain same for provision number 25 as well as for the provision number 64, as decided in Delhi High Court's Ajay case and as decided in one foreign jurisdiction case of Globe case, where it has been categorically stated that the interested person will be a person who has got some genuine commercial interest in the subject matter, and whose commercial interest will jeopardize or will get jeopardized in case there would be the continuance of the patent in the patent register. I mean, in case the patent will continue as a patent in the patent register. Well, another important thing of section 64 to be understood by all my viewers, which I have highlighted categorically, that there are two kinds of methods to go for the revocation. One is revocation petition to be filed to the Intellectual Property Appellate Board. Another is revocation petition in a counterclaim, especially in a counterclaim, and that counterclaim is what? That counterclaim is in a infringement suit, friends. That counterclaim is in a infringement suit. So, let us see what the Supreme Court has recently stated. As I have told you that there are two kinds of methods available under section 64, and generally it used to be presumed, or earlier it used to be presumed by the person seeking or thinking of filing the opposition and revocation, that he has got multiple remedies. But this case law, friends, has streamlined the multiplicity of proceedings and curbed the multiplicity of proceedings by saying what? It reads that based on the two remedies contemplated under section 64 of the Patent Acts, it seems that the use of the word or in section 64(1) demonstrates that the liberty granted to any person interested to file a revocation petition to challenge the grant of a patent to an individual cannot be adopted simultaneously by the same person. That is, firstly by filing a revocation petition to the Intellectual Property Appellate Board and at the same time by filing a counter claim in a suit for infringement. Well friends, I would like to tell you something about it. As I told you that under section 64 there are two kinds of methods available to the person seeking of filing the revocation application. One is going by the revocation petition to the Intellectual Property Board, another is filing a counter claim in an infringement suit. So what the court has said recently in 2014 in one case law, which I will be jumping very soon, it has categorically stated that these two remedies provided under section 64 will never go in tandem. Or what does it mean? What the court meant, court said that these two remedies are not conjunctive remedies available to the person to be used simultaneously or available to the person to be exhausted simultaneously. He has to either choose the remedy in the form of revocation petition to the Intellectual Property Board or the second remedy available under section 64, which is a counter claim to be filed in the infringement suit before the High Court. He has to choose either, I mean one out of these two. He cannot take advantage of multiple remedies available and go for filing the multiple remedies or exhausting multiple remedies, because that ways he will be troubling the patent applicant, he will be troubling the patent owner and the patent holder as well as the controller. The office will be inundated with such kinds of multiple proceedings. So that is why the court has streamlined multiplicity of proceedings by saying it clearly that one remedy has to be adopted at one point of time, and once the person has exhausted that remedy, he will never be able to use or avail the next remedy available in the row. I mean once he exhausts one remedy, he will never be available, or the another remedy will never be available to him for his disposal. Well, I am coming to that case law, friends. This is a very important case law where court has categorically stated. This is called Dr. Alois Wubben and another versus Yogesh Mehra and others. It is popularly known as Anarcon patent litigation. It's a civil appeal in the year 2013 decided by the Supreme Court in 2014, Indian Supreme Court I mean, and this case law is popularly known as Anarcon patent litigation. Well, this Dr. Alois Wubben is also called the creator of the wind turbines, and he has got around 2800 patents all over world. I mean around 100 patents he has filed in India and has obtained protection for in India. He, along with the respondents here are Yogesh Mehra and others. I mean he along with the respondents started some initiative in India, started doing some kind of enterprise in India, but there came a rift between their relation or between their business relation. Because of that, Dr. Alois Wubben filed a patent infringement action against the respondents, against the Yogesh Mehra and others. Yogesh Mehra and others, in reply to the plaintiff's allegation, plaintiff's patent infringement allegation, did what? They filed the revocation petition to the Intellectual Property Appellate Board first, and then later on they filed the counter claim on the same grounds. That was the issue in question. I hope you have understood the fact sheet, friends, that Dr. Alois Wubben and another, I mean that especially Dr. Alois, who is the inventor of many inventions, or who is the creator of many inventions, patent holder of around 2800 patents all over the world. He, along with Yogesh Mehra and others who are Indian respondents in this case, he along with them started some enterprise in India, but there came a rift into their relationship. These respondents, Yogesh Mehra and others, were sued by Dr. Alois for the patent infringement in India. In reply to that, Yogesh Mehra and other, the present respondents, they filed a revocation petition to the Intellectual Property Appellate Board as well as counter claim in an infringement suit filed by the Dr. Alois. I mean in the same suit they filed a counterclaim as available, as an option available under section 64 to them. What the court found, that ways it will be really difficult for the court to determine and to finally dispose of the matter in an expeditious manner. That is why court held that a revocation petition, if you can see the screen, it is quite clearly written, the findings of the court are quite clearly written on the screen. It held that a revocation petition before the Intellectual Property Appellate Board or a counter claim in an infringement suit before the High Court are not conjunctive, and a choice needs to be made between the two by the person availing these remedies. That is quite clearly written, that a revocation petition before the Intellectual Property Appellate Board or a counter claim in an infringement suit before the High Court are not conjunctive, and a choice needs to be made between the two by the person availing these remedies. So now the court with this case law has streamlined multiplicity of proceedings, has streamlined the procedure or methods available under section 64, which usually were opted by the people or interested person, usually were opted by the people simultaneously, in tandem or subsequently sometimes, but now it is clear that only one remedy is to be used, other remedy will not be of avail, will never remain available to the person in case he has exhausted one remedy, either a remedy in the form of revocation petition to the Intellectual Property Appellate Board or a remedy in the form of counter claim in an infringement suit. What else the court has said in this case law? Let us see. Based on the court has said, held that due to the opening words of section 64, which says, as I have discussed with you, that section 64 starts with what? That it is a subservient clause, it is a subservient provision, subservient to other provisions of the Patents Act 1970. And by the reading of the very first sentence of section 64, it aptly gets clear that section 64 is subject to other provisions of the Patent Acts, even to section 25 of the Patent Acts. So what does it mean? Finally, it means that if one avails the post grant opposition proceedings, he cannot make use of section 64 on the similar grounds. And if under section 64 or within section 64, if one files a revocation petition, he cannot make use of the counter claim to be filed in an infringement suit. As I have told you that there are many remedies provided under Patents Act 1970, and two are very crucial: oppositions, which are especially the post grant opposition of section 25(2) and the revocation. When one uses 25(2) and files a post grant opposition and exhausts this remedy, he will never be eligible to make use of the later remedy provided under section 64, because section 64 is also what? It is also subservient to the other provisions of the Patents Act 1970. It has to be read subject to other provisions of the Patents Act 1970. What 25(2) says? That interested person or the person interested can file the post grant opposition. 64 also says the same thing, that the interested person can file the revocation petition. Well, that is how we can easily make out that now it has been made clear that only the one kind of a proceeding is to be opted, no multiple proceedings are to be opted by the individual. Well friends, if you would like to read more about this case law, this is available online. I can supply you if you will write to me on my email ID, and that can be obtained from the CEC. Well, I wish you a good day ahead. Thank you very much. Thank you.
With this note, thank you sir, thank you once again for giving us once again a productive session. And dear friends, as Mr. Ashwin Isabal himself said, that if you have any queries, then of course you can mail us. You can mail us at info.cc@nic.in, and further if you wanted his ID, we would provide you that also. And for accessing this lecture, we have a YouTube for you, where we upload lectures for you. You can access this lecture as well as yesterday's lecture, so that you could get the content in chronology, that is on infringement. So dear friends, we would be meeting again very soon and would be discussing on some of the other aspects on intellectual property rights. Till then, take care, goodbye. Thank you sir, thank you so very much.